Welcome. Can you hear me? Is the mic working? Very good. To this evening's candidate forum, presented by the Ottawa County Bar Association and the League of Women Voters of the Holland area. I'm Paula Lewison. I'm president of the Holland Area League, along with several other members of the league who are helping here tonight. We're proud to offer this opportunity for voters in Ottawa County to learn more about candidates running for the newly created Family Circuit Court Judge. The League of Women Voters is a nonpartisan political organization that encourages informed and active participation in government. We work to increase understanding of major public policy issues and through education advocacy to influence those policies. As always, through the decades and over a century, the League is open to all people becoming members. So if this interests you, please join us. An important point here, the League never supports or opposes individual candidates. But we do take positions on issues that we have studied and have come to a consensus on the local, state, and national level. Our mission over the last several years has been to empower voters and defend democracy. Now at this time in the forum, I request that you please turn off all cell phones and other electronic devices. No cameras or recorders are permitted other than those authorized by the League. This event will be videoed. We're using the county's equipment. This is an experiment for us. We're new at this, and hopefully we'll all be able to see it on websites for the bar and the League. In keeping with our mission this evening, we've invited candidates who are running for the new Ottawa County Family Courts judgeship, and they will be on the ballot on November 8th. Keep that date in mind. It's an important date. We ask that applause be held until the forum is completed, when we can then thank all the candidates for participating. To introduce the candidates, we have Paul Kraus and we have Mercedes Watts. Welcome, and thank you for both for participating. Our moderator this evening is a longtime League member and supporter, Diane Nelson, and she will explain the forum rules and then get the conversation started with our candidates.
Thank you, Paula. The reason that I'm the moderator is I don't live in Ottawa County. I'm from Allegan, and so, I will not, sad to say, be voting on either one of our candidates here. However, I am so glad that you're all here and that you've turned your cell phones off, and we will get started. The two candidates are both going to have 4 minutes for an opening statement, which was determined alphabetically, and then we'll just alternate between the two of them. We have some questions that have been submitted, and we will be working on those that have been earlier submitted, but we will perhaps have time for audience questions as well. The other things that I have to tell you are that time limits will be strictly observed. We have timers from the League here who will, cut the candidates right off when they go over the limit. And all candidates, both candidates, I should say, are able to answer all the questions. So we ask you again to refrain from applauding or hissing or booing or, that kind of thing. And let's get started, okay? We will begin with, alphabetically by last name, Mr. Paul Kraus. Welcome.
Thank you. Thank you so much. I wasn't nervous until I saw my wife, Heidi, come in, and I know she knows too much, so I'm a little nervous about that. But so great to be here tonight with all of you. A special thank you to the League of Women Voters for affording this valuable opportunity to our community. Thank you also to the Ottawa County Bar Association, President Armstrong, for agreeing to facilitate this tonight. And then to the judges that are here, to all of the attorneys that are here tonight, and then also to the citizens. This is an amazing opportunity for Ottawa County. We are going to be afforded a Fifth Circuit Court judge, and the position is going to be designated as a family law position. This is a position that is going to handle some of our most vital cases for Ottawa County: child abuse, divorce, custody, guardianship, adoption work, the types of cases that can have a lasting impact on families and our community for generations to come. It's important that we select somebody that has the experience and the temperament for the position. I've spent 17 years as an attorney in family law. I started as an assistant attorney general handling child protection cases for 9, almost 10 years. My wife then graduated her PhD in art history and was lucky to be selected to go to Hope College as a professor. We moved our family to Western Michigan, where I soon there joined Cunningham Dahlman Law Firm, where I was handling divorces, custody, adoption, child abuse work, family law work at Cunningham Dahlman. Received a phone call one day from Lee Fisher, who was at the time was our chief deputy prosecuting attorney locally. Now he is our prosecuting attorney, who said we have a need for a prosecutor in Ottawa County that has a specialization and who has worked in child abuse cases, and invited me to join the prosecutor's office. It was humbling to not submit a resume and to be considered for that position. But more importantly, it was an honor to be able to go back into public service and accept that call to make a difference in our community. I now serve as our senior assistant prosecuting attorney for Ottawa County, a position that handles our child abuse cases and also it manages our family division for the Attorney General's, or for the prosecutor's office. And it would be an honor to be able to put that work and that experience to work for our county. It's important, as I indicated, to have somebody that has the knowledge so that on day one, they can make a difference in the lives of families within our community. I promise you, children and families will be my top priority if I have the privilege to be able to continue to serve as your next 20th Circuit Court judge.
Thank you.
Thank you.
We'll now hear from the other candidate, Ms. Mercedes Watts.
Good evening. My name is Mercedes Watts, and I am running for the new Circuit Court Judge position here in Ottawa County. Everyone always asks me why I want to be a judge. I want to be a judge because I believe I can help the most people as a judge. Judges have a huge impact on people's lives, and I want to pass along the positive experiences I've had and be a positive impact on people. As you know, this is for the family division, and family law is my specialty. I'm a Grand Valley alum. I attended DePaul University for law school. Upon graduating from law school, I returned home to West Michigan, where I opened my own firm, practicing primarily family and landlord-tenant law. After that, I worked for legal services, doing the same, family, landlord-tenant law. I was then an assistant prosecutor doing family and criminal law, and now I am a public defender for Ottawa County. One of the main things I would like to change is how petition orders to remove children are handled. I've practiced in multiple counties across Michigan, and what I've seen is when a petition order is received, it is immediately signed. The first hearing isn't held for 1 to 2 months down the road, but by then all the damage has been done. Families torn apart, children traumatized, and county money has been spent needlessly. What I want to do is hold a hearing before that removal happens. So much comes out during these hearings, and I believe they are vital before deciding if a child should be removed or not. These hearings take time, but I am willing to put in the work to ensure that I am not having a child removed on unsubstantiated allegations in a petition. My goals as judge is to keep families together, provide resources to families and juveniles aimed at rehabilitation and intervention, just like the Michigan Task Force on Juvenile Justice Reform. This task force was formed by our governor last year to become compliant with the Juvenile Justice and Delinquent Prevention Act, which was enacted by Congress in 1975. The purpose of the task force was to lead a data-driven analysis of Michigan's juvenile justice system and recommend proven practices and strategies for reform grounded in data, research, and fundamental constitutional principles. There are 23 members on this task force, which include Lieutenant Governor Garland Gilchrist and Tom Latigue, who is the juvenile court director here in Ottawa County, along with 21 other individuals. Throughout this past year, they have researched Michigan's juvenile justice system, which include reviewing local and state policies, court rules, and administrative policies and practices, holding over 100 focus groups and interviews, and having ongoing conversations with juvenile justice agencies. According to the task force, a few things that their research revealed is that Michigan lacks the policy framework and service infrastructure necessary to ensure that the youth who are at a low risk of reoffending and are diverted from juvenile justice system statewide. Michigan also lacks statewide policies and tools to ensure that predisposition detention is used only for youth who are a public safety or flight risk, and that minority youth are disproportionately represented in all parts of the juvenile justice continuum, and a few statewide structures exist to address these disparities. It also found that minority youth are petitioned for court at 2 times the rate of white youth and more than 1.5 times as likely to be adjudicated as their white peers. Minority youth are detained at 6 times the rate of white youth, and the average length of stay in detention is 7 days longer, and that minority youth are placed as state wards at 3 times the rate of white youth, and there is limited attention statewide to ensure that the residential system is equipped to serve youth of color effectively. That's just a few things.
Thank you, Ms. Watts. In keeping with our alternating arrangement, we will ask Ms. Watts to take the first question. And remember, questions are answered in 2 minutes. Opening statements were 4 minutes. Ms. Watts, what qualities do you have that will make you a good family law judge?
In addition to the qualities I already stated about my education and experience, also my personal experiences. I am a Black woman in a field dominated by white men. My experiences are very different from my colleagues, and therefore I have the ability to see things differently and see things from different perspectives and different angles. And also having been an assistant prosecutor and now a public defender, and combining that with my personal experiences, I think that is what qualifies me.
Thank you. Mr. Kraus, the same question. What qualities do you have that will make you a good family law judge?
Yeah, this is a position where you need somebody who's a good listener, somebody that doesn't just have the answers immediately or come to a snap judgment. You need somebody that has the temperament to be able to sift through the rhetoric and the facts that are presented in court. And I've spent 17 years as an attorney distilling those qualities to be able to kind of hone in and learn how to be able to synthesize information, effectively handle high volumes of cases and information that comes before a court, but to be able to listen and to have the empathy to hear what comes in, to treat people with fairness and dignity and respect. Those are skills that I think would serve me well as a judge.
Thank you. You can stay standing if you want because you get the next question.
Wonderful.
Starts with you. Yep. What is your experience with abuse and neglect, domestic relations, and juvenile delinquency cases?
It's interesting because all 17 years of my legal experience are exactly in those areas. Starting as an assistant attorney general, handling child protection cases for the state of Iowa, then moving to Cunningham-Dolman, where I was with people on their best day when they were adopting a child and on their worst day when they were going through a divorce, and then now being a prosecutor whose division handles our child abuse cases, our juvenile delinquency cases, our mental health commitment hearings, and cases that involve families. All 17 years of experience will serve me well in this particular role. I look forward to using it to serve the voters of Ottawa County.
Thank you. Ms. Watts, same question. What is your experience with abuse and neglect, domestic relations, and juvenile delinquency cases?
That has been my primary focus since I graduated law school. When I opened my own firm, the majority of the cases that I took were family. So dealing with custody, divorce, personal protection orders, anything, evidentiary hearings, you name it. And that's what I did for over a year. And then moving to legal services, I did the same. It did not change. It did change when I became an assistant prosecutor because then my focus shifted. I was no longer on the side of the individual, but on the side of the state. And now, being a public defender for Ottawa County, this is actually the first time I'm not actively practicing family law because I'm not allowed to.
Thank you. Ms. Watts, a follow-up. What have you seen as the most difficult aspects of abuse and neglect, domestic relations, and juvenile delinquency cases? The difficult aspects of them.
I would have to say the most difficult aspects is internal. You are dealing with people who are traumatized, who are going through trauma themselves. And it's hard not to take all of that on because you want to be that saving grace for them. You want to be that safe space for them, but you also have to remember that you have a family, you have a life, and you can't bring that home. So that is the most difficult part, is basically I think the work-life balance of it, because it is hard. Dealing with all that emotion, all that grief, and being, the attorney, the therapist, the shoulder to cry on for your client.
Thank you. Same question. What have you seen as the most difficult aspects of abuse and neglect, domestic violence, and juvenile delinquency?
I appreciate that question. I've had over 1,000 appearances in Ottawa County Family Court over the years. I also have an opportunity to serve on Ottawa County's Child Death Review Team. We review with a team of professionals child death that occurs in Ottawa County that is not based on natural causes. And each and every one of those cases sticks with you, and you take that home and you internalize that, because there's not one of those cases where you wouldn't give anything to be able to turn that clock back and prevent that accident or that incident from happening again. What I enjoy about that work is there are tangible solutions that come out and suggestions for our community to hopefully prevent a similar death from happening again. But there's nothing that can be done. There's no punishment, there's no service, there's nothing that can be done to restore the life of that young person and that child that passed away. And I take those cases with me everywhere I go, and those shape my experience to hopefully make me a better attorney and a better advocate in the system.
Thank you. Mr. Kraus, what do you see as some of the biggest barriers? I mean, they could be economic, they could be legal, barriers to equal access in domestic relations, abuse and neglect, and juvenile delinquency cases.
Sure. Certainly there's a shortage of legal aid and free and subsidized attorneys for those that need that counsel. I think Ottawa County has been kind of on the front lines with our self-help center to hopefully equip individuals that are going through domestic relations to be able to do matters on their own, to file motions, and to be in court. Ideally, there would be free counsel for everybody and counsel for everybody to help them navigate the process, because we know when there are attorneys alongside folks that are going through some of the most difficult times in their life, it results in better justice for all. So I'm a big supporter of our local Western Legal Aid and indigent services. Those are critical for there to be justice for all, and I wholeheartedly support them.
Thank you. Ms. Watts, what do you see as some of the biggest barriers to equal access in domestic relations, abuse and neglect, and juvenile delinquency cases?
I believe the biggest barrier is economic. A lot of families are struggling because they can't find or afford good and reliable child care or medical insurance or affordable housing. We don't have a lot of funding for that. And when they end up in a bad situation, if they have kids, then they end up in court. And that only makes the situation worse. We don't have an indigent defense for our juveniles. That's actually one of the policy changes put forth by the Michigan Juvenile Task Force. And I think it is so important. We could help so many families, so many children, so many people who enter the system if we had more funding and more resources. And even with the Juvenile Justice Task Force, just forming that and then doing this research and coming up with these policy changes has put us in compliant with the Juvenile Justice and Delinquency Prevention Act, which we do get funding from. And so I believe that that is the biggest hardship.
Thank you. Also, Ms. Watts, what community resources are you familiar with regarding domestic relations, abuse and neglect, and delinquency cases?
Community, probably Lighthouse and Resilience. Women.
Can you say what those are?
Yes, they are nonprofits that help women with children who have been in a domestic violence relationship. They help them get on their feet. They're a saving grace. They're an escape for them. Also, Women of Color Give is another one. They all do the same thing, as in help women who are in domestic abuse relationships with or without children. They could all use more funding because, the more money you have, the more people you can help. And those are the ones I'm familiar with.
Thank you. Mr. Kraus, what community resources of any kind are you familiar with regarding domestic relations, abuse and neglect, and delinquency cases?
Well, we're very fortunate. We have a number of great community partners that are on the front lines taking on important issues such as housing, Good Samaritan, Community Action House, for example. Substance abuse issues, you would have Ottawa Addiction Recovery, which is now Reach for Recovery, wonderful organization in our community that is providing services directly to those that are going through substance abuse issues they have. On the mental health front, of course, we have Western Michigan Psychological Services. There's a number of local providers that provide reduced rates for those that are indigent or can't afford full services because they don't have insurance coverage in that particular area. So all of those services are available to our community, and there's a lot of kind of regional partners that we can access as well in Grand Rapids and in Allegan, for example, whether it's Sylvia's Place or Resilience on the domestic violence front, providing great services to our community.
Thank you. Mr. Kraus again. How do you envision the new centralized family justice center helping families in Ottawa County?
Boy, do we ever need it. And I'm glad that we're on the grounds where it's going to be built. Ottawa County needs to go to a one judge, one family model. It's essential. Right now, you can have a family that's going through the process that has a case out here in Fillmore, and then they may have a different case related to the family with a different judge up in Grand Haven. So having one judge that can see exactly what is going on with that family and have a better comprehensive understanding of the needs of that particular family is critical. And I know it'll be completed in early 2024. It's going to result in more just, favorable, equitable rulings by having one judge with one family.
Thank you. Ms. Watts, how do you envision the new centralized family justice center helping families in Ottawa County?
I have to say I completely agree with Attorney Kraus. Definitely having one place, one judge, because all judges see things differently, they decide things differently, and having a different judge come in on a separate issue that could be related to the other issue makes things extremely complicated and messy. And so I definitely agree, just having one judge, one place makes it so much better for the families involved. And you know what's going to happen, they know everything that's going on, and eventually you'll learn how that judge operates. And I think that's so important and extremely helpful.
Thank you. Ms. Watts, I know you spoke to this briefly, but I would like you to expand on this. What is your experience with domestic violence issues in the legal setting?
Domestic violence issues in the legal setting is that I've had clients I've represented, men and women who have been victims of domestic abuse. I have helped my clients escape abusive relationships, some who've had children and who have not. I have seen the good, the bad, the very ugly, and the scary, all while practicing family law. And again, I have to say, it definitely takes a toll on you. You have to be equipped to handle the trauma that comes with this and still be there for your client and be there for their families, because as much as you're going through, they've got it worse. This is the worst day of their life every single day. And yeah.
Thank you. The same question, Mr. Kraus. What is your experience in the legal setting with domestic violence issues?
What an honor and privilege it has been to be able to walk alongside those that are survivors of domestic violence. At Cunningham Dahlman, representing women and men that have been victim of domestic violence and being able to connect them to services in the community to try and make them whole. It's impossible to redo that history, but to be able to serve them and find solutions for them and their family and to keep them safe and their children safe has been one of my greatest honors when I was doing that work specifically. Now as a prosecutor that works within our child abuse system, our top 3 issues we have for child abuse within Ottawa County are substance abuse, mental health related issues, and domestic violence related issues. And to be able to pull a child out of a home where there is active domestic violence, to teach them what is right so that they don't realize that that's normal and kind of perpetuate that cycle, is some of the most amazing work that I do now, to be able to break that cycle of abuse and hopefully have a family in the future that does not have domestic violence with it.
Thank you. Now we're turning to a technical question. What types of hearings do you feel can effectively be handled over Zoom?
Oh,
And also, what types cannot?
great question. So my opinion has kind of changed a little bit on this over time. I remember when Zoom was first implemented, and it was implemented kind of on a widespread basis because of the circumstances we were in at that time. I was highly opposed to it. There's something about being in court, being before a judge, bringing the parties together to discuss an issue that always has been central to the fabric of who I am and my beliefs. But then I saw on our abuse and neglect docket that when you have parents that can participate in abuse and neglect review hearings, which are required every 3 months, and for those that aren't familiar with that system, on the rare occasion a child has to be removed from a family. The statute says every 90 days you have to come back with a caseworker who's assigned to that case, the judge, the attorney for the child, the parents, and the attorneys for the parents to come together to get an update on the progress of that particular case. And what I found is that some parents couldn't get to court because they had to work. Other parents couldn't get to court because they had transportation issues. And by allowing them to participate by Zoom, you get greater participation from the parents. And that's critical, because the whole process is designed to empower parents, to give them the skills they need so that we can get children as quickly and safely back to those homes. Trials, termination hearings, those should be conducted in person. Other types of proceedings are appropriate for Zoom.
Thank you. Ms. Watts, what do you think about that? What types of hearings do you feel can effectively be handled over Zoom, and what should not be handled over Zoom?
I believe that most hearings can be handled over Zoom. Pretrial hearings, arraignments, status conference hearings. I found that Zoom was a learning curve. It did take us a minute to get it together and figure out what worked best for us and the court system. But once we did, it was amazing. You did see a lot more participation, a lot less failure to appears. And if something were to go awry and your case got moved back or got kicked or we didn't start for a couple hours for whatever reason, that person wasn't missing work. And that's what I found was a lot of, they would have to take the whole day off work. They were not getting paid. They would have to find childcare if they had younger children. So having Zoom just made it so much more accessible for a lot more people in the community. When it comes to parental termination hearings, I believe those should be held in person. It's a very tough hearing. Those can last hours, and you want to be in person for those. I believe adoptions should be in person, only because that's the only fun part of a family court is adoption, and you wanna relish in that joy with this family, right? And it's really nice to do in person. And any trials, I also believe should be held in person.
Thank you. Ms. Watts, a judge, particularly judges in these juvenile cases, need to make important decisions based on the information presented, and at times with very few good options. Do you feel you can do this? Why?
Yes, I do feel that I can do this. I believe I can do this because of Ottawa County slogan, right? It's where you belong. And I take that to heart. And to me, that means being compassionate, being accepting, being fair, and listening. Yeah, you may not have a lot of choices at your disposal, but keeping those things in mind and recognizing that you've got to do what's best for the child, or you've got to do what's best for this family, and then just making that decision.
Thank you. Mr. Kraus, the same question. A judge, as you know, needs to make important decisions based on the information presented, and at times with very few, no good options being available. Do you feel you can do that, and why?
I'm up to the task, and I remember when I started at the Attorney General's office, I didn't know the subject area that I was going to be practicing in. And I knew how difficult it was initially to be a successful attorney and advocate within the space of child abuse law, because it's an area that takes years of experience to be able to develop an understanding of things like trauma. Things like understanding that sex abuse oftentimes doesn't have physical trauma. To understand the domestic violence wheel and the intricacies of the domestic violence wheel and what it means to be able to pull a child or a survivor out of that situation. All these things you don't read in a law book. All these things aren't just handed to you and you know them. It takes case after case and training after training in collaboration with community partners to be able to sort of get it and to be able to still know that there's a lot of room for growth in that area because it's such an expansive area. And so I promise you, I will use my 17 years of experience, the trainings, my time in court, and all that collaboration I've had with community partners to good use to hopefully get it right most of the time, knowing sometimes there just isn't a good decision.
Thank you. Stay right there. What has been your experience with high asset divorces?
Ooh, great question.
I mean, we're talking millions here.
Sure. Yeah, I was lucky to be at Cunningham Dahlman, and I was lucky to work with a number of sharp attorneys at Cunningham Dahlman that brought in a lot of cases from Allegan County, Ottawa County, and also Kent County. And I was able to learn from some of the best and sharpest attorneys in that particular area. One of the most complex divorce cases I handled, and Ken Breeze, who was just an amazing soul at Cunningham Dahlman. Unfortunately, he recently passed away, but Ken was such a generous person. And he had brought in a case involving, in Allegan County, involving millions of dollars of farm assets. And talk about a complicated case. When you have land you have to sell, when you have tractors, when you have grain, when you have all of these different assets that have different valuations, some of which is new and can be sold right away, some of which can't be sold based on the time of the year. And so I had to figure out a strategy for the client at that time to be able to effectively divide those millions of dollars of assets. And I know as a judge in this area, you're going to get cases where there's $2,000 in assets, and you're going to get cases where there's $15 million in assets. And you need to be able to treat people with dignity and respect, no matter where they are on that spectrum. Because that $2,000 or $20,000 is just as important to that family as it was for that family that I helped, that mother that I helped assist in dividing assets on $1 million case.
Thank you. Ms. Watts, what has been your experience with high asset divorces?
My experience has been very minimal, maybe 3 cases combined from my private practice and legal services. And what I learned is that good appraisals and mediation was key. I was fortunate enough to have judges who saw that dollar amount and said, you know, like, this is a lot. I would prefer you guys go to mediation anyway, but definitely for this, because we were talking millions of dollars in assets. So being organized, for sure, staying calm so that I could keep my client calm, because we're talking about her livelihood, her children's livelihood, and dealing with the attorney on the other side because he's thinking about his livelihood and his children's livelihood. So just definitely just having that compassion and understanding, walking your clients through this process. And I think championing mediation was key, because although we went to mediation multiple times in all of those cases, they were able to come to an agreement that they could both live with. And it was because of those cases that I actually chose to become a civil mediator. And I went through the training and got certified, because it's so nice to be able to sit at the same table across from one another, work out your differences. Oh, okay. And work out your differences. And, you know, if you need to caucus, you caucus, but you then come back. And yeah, that's my experience with it.
Thank you. Ms. Watts, what do you feel is the primary role of the court in high conflict domestic relation cases that include resist-refuse dynamics? Well, yeah, when I can. What do you feel is the primary role of the court in high conflict domestic relations cases that include resist-refuse dynamics? Where someone just won't engage.
Okay.
Resist, refuse.
Okay. Well, if one, if they aren't showing up to court, that's a different story than, they are failing to appear when summoned to do so. If they are in court and they're just refusing to participate, then that's the answer you accept, right? If you're asking them a question and they're refusing to answer you, that's their answer. But the other party, they are cooperative, they are doing what is asked of them, and they are trying to participate and move this case along. You can't let one person stall this case. That's not justice. You can't let someone take the reins of the court. We cannot allow that.
And what is the role of the court in that case?
The role of the court is to keep moving that case forward. So you have one party who's just refusing to participate, whether they show up or not, the case is still going to move forward because it's not fair to that other party to have everything stalled because someone else wants it stalled and they want to take control of the court. That's the role.
Thank you. Let me just repeat that, Mr. Kraus, because it's complicated. What do you feel is the primary role of the court in high conflict domestic relations cases that include these resist-refuse dynamics?
Sure. And you see it all day long, unfortunately, where there's high conflict in cases, particularly cases that involve children. And the court needs to be strong. The court needs to be a leader and not allow one party to be able to stall the proceedings or dictate or force their agenda and will on the court proceedings. You need somebody who's fair, but you also need somebody who's firm, that can say, enough is enough. We're not going to accept parties that aren't showing to court. We aren't going to accept parties that are somehow stalling out the process or interfering with fair and equitable justice in the courtroom for domestic cases, including cases that involve children.
Thank you. Let me ask you your opinion.
Oh.
What is your opinion of some of the recent efforts to mandate joint legal and physical custody, including equal parenting time, instead of leaving that determination to the court?
Yeah, well, I'm always a firm believer that a child needs both parents. A child needs a strong father, needs a strong mother, if that is the dynamic within that particular family. And so it's important that a judge not be predisposed to give a mother or a father primary custody or more parenting time just based on gender, but rather should be looking at the unique circumstances of that case, established custodial environment, all the 12 best interest factors that exist on the case, and make a detailed and individualized analysis on that case to always remember to do what is in the best interest of that child that's before the court.
Thank you. Would you answer that too? What is your opinion of some of the recent efforts to mandate joint legal and physical custody, including equal parenting time, instead of leaving that determination to the court?
Well, I agree that the 12 best interest factors need to be taken into consideration. You also have to take in each family's different circumstances. Similar things may lead a family to friend of the court, but the circumstances behind that could be absolutely different, and it's important to recognize that and recognize what this family is going through. And also the child, if the child is of age, speaking to them, in my opinion, is also very important. And if able, speaking to them alone without either parent interfering. I do believe that if the parents can come to an agreement themselves, that is always the best option, because then you're not using your child or children as pawns, which can happen when you're going through divorces or difficult situations. And in the end, I feel that if that is happening, then it's the child that always gets hurt. So you really have to keep in mind what is best for this child or children, And if the parents are amicable, that's great. If not, you have to look at those factors. You have to look at those circumstances. And if able, you have to speak with the child and then make that decision.
Thank you. Let me ask you, Ms. Watts, how familiar are you with the custody and parenting time best interest factors and the determination of an established custodial environment?
Well, I'm very familiar with the best interest factors. I would always look them up whenever it came to when we were fighting for custody or a change in parenting time or a change in custody or anything like that. What was the second part of that
Well,
question?
the second part was in addition to the best interest factors, the determination of an established custodial environment.
Well, established custodial environment. I think that looks different for everyone. Not every family dynamic is made up the same. We all are different makes and models. So established custodial environment could look very different based on that family circumstance, based on that child. So you really have to look at that at a case-by-case basis and still looking at the 12 best interest factors and the circumstances surrounding the family.
Thank you. And there are two parts to this question, as I'm sure you heard, Mr. Kraus. How familiar are you with the custodial and parenting time best interest, I think you've said 12 best interest factors, and the determination of an established custodial environment?
Sure. Well, established custodial environment isn't something unique to each family. It's a standard that's espoused in the Budvarka case here in Michigan, which is the Sentinel case that establishes what an established custodial environment is and the importance of this established custodial environment. In terms of the 12 factors, were used routinely as part of my practice at Cunningham Bowman doing family law cases. The one that I always thought was considerably notable is factor J, which talks about a parent's ability to kind of foster a relationship between the other parent and the child, or stated differently, alienating behaviors to kind of push that child away from the other parent. Very important factor, but 12 factors you routinely use as part of your family law practice. I'm familiar with them and use them all the time.
Thank you. Next question. What factors do you believe are most important when deciding to release a child from detention? Why?
That's a great question. One of the most important factors would be community safety. You know, where is the situation now under control to the point where that child could be released? Another factor that's important is an understanding of the family dynamic, where that child came from. Can they go back to that home? Is there another placement that would be appropriate for that child? Certainly you need to consider the seriousness of the offense. You're dealing with something like domestic violence. Sometimes, just a few hours can calm that situation down. If you're dealing with attempted murder or something on the other extreme side of things, you're probably going to have that dude restrained and held for a longer period of time based on the dynamic within that family and then community safety.
Thank you. Ms. Watts, what factors do you believe are the most important when deciding to release a juvenile child from detention and why?
I think one of the most important is what offense that juvenile committed, how long they've been in detention, and what they have done while in detention. If you have a serious crime, I want to see, like, what have you been doing? You know, I'm not the same person I was a year ago. People change and they grow, especially children. So I really want to look at the offense. I want to see how long they've been incarcerated, and I want to see what they have been doing to better themselves. And furthermore, you know, who have they been talking to? Like, what do the counselors have to say? What do the staff have to say? How have they been doing? if they had a temper problem, is that getting better? If they were having trouble in school, is that getting better? It doesn't have to be perfect, but are they working towards bettering themselves so that they can have a better future when they are released? And that's what's most important to me.
Thank you. This is somewhat redundant, but we want to make sure that we know everything about you. What areas of law have you practiced in?
So I have practiced bankruptcy law, family law, landlord-tenant law, consumer law, criminal law. I've dabbled in tort law. I did a lot. When I was first starting out, no one would hire me because I didn't have experience, and I couldn't get the experience without getting a job. So I made the experience myself. I started my own firm, and I took any and everything that came my way. I also worked for an organization called CAP, Court Appearance Professionals. So when someone needed coverage, whatever it was, they provide me with the documents, a brief understanding of the case, and I would go and cover it. But primarily, it has been family and landlord-tenant law, and within the last couple of years, criminal.
Thank you very much. Mr. Kraus, what areas of law have you practiced in?
Yeah, thank you. Thank you for that question. At the Attorney General's office, it would have been primarily family law, criminal law, and appellate practice, and an opportunity to have oral arguments in front of the Iowa Court of Appeals and Iowa Supreme Court, but primarily it was a family court, family law practice area. When I went to Cunningham Dahlman, nice thing about a larger law firm is you get exposure to varied areas of law. It was at Cunningham Dahlman that I did some criminal defense work for those that were wrongly accused of a crime. Did family law work that I mentioned earlier, doing adoption work, guardianships, divorce, custody work, child abuse work. And then now, as a prosecutor, I handle criminal cases, so I do felony child abuse cases for Ottawa County. I also do mental health commitment hearings for the county, juvenile delinquency cases, our child abuse and neglect docket, and so hopefully a wide area that will give me kind of a good backbone and experience to render just rulings.
Thank you. Let me ask you this. What is your experience as an attorney working with CPS DHHS?
Yeah, I've had a great relationship. We have a first-class CPS DHS here in Ottawa County that works so hard to put preventative services in place to ensure that children only need to be removed in the most serious of situations. Went back, I was curious, I looked at the data. We have over 320,000 people in Ottawa County, citizens in Ottawa County. We had 39 petitions total last year where there was needed to be court involvement to remove children out of a family for the most serious of circumstances. DHS handled hundreds and hundreds and hundreds of calls came in, and then also handled so many cases where they put services in place voluntarily with families to kind of walk alongside and to be able to ensure that those children don't need to be removed out of that home. So I work closely with DHS. Hope they agree with me most of the time. Sometimes they don't. That's how it works with an attorney-client relationship. But we just have a lot of heroes on the front lines in Ottawa County trying to work through substance abuse, domestic violence, mental health, criminal issues, parenting skill issues, housing issues, all the varied issues that come up and face families.
Thank you. Ms. Watts, as an attorney, what has your experience been working with CPS DHHS?
As an attorney, my experience has not been the best working with CPS and DHHS. The situations I have seen have been traumatic, to say the least. I usually have good relationships whenever I would call on a case. If I was the sole practitioner, or if I was working for legal services, or as an assistant prosecutor, I've just not had the best experience with them. I don't believe that they are bad people. I believe that CPS is overworked, underpaid, and they need more help. I've had situations where in court, a CPS investigators have flat out told me they never investigated. I've had cases where they told me they didn't investigate, but someone else investigated, but that person couldn't be there today because that person no longer works for the agency. That is my experience with it. And I think just having the experience I've had, and I know that that's not everybody's experience, just having the experiences I've had just allows me to see things differently and to be another check and balance when it comes to petition removal orders.
Thank you. We have a little bit short of half an hour left, and we have 3 or 4 more questions to ask our judicial candidates. But if you have a question for either one of them, would you be so kind as to write it down? There are people that will be coming around and picking up any question that you have. If you would like to ask one, I believe will have time to do that. So just, raise your hand or pass it down or whatever you'd like to do. Meanwhile, I will go on and just continue with the league questions that we have, but if you'd like to, we have people standing by, so please participate.
Testing.
Okay, thank you, Peter. This question is for Ms. Watts with our alternation. It seems to come from personal experience, and it concerns domestic abuse which continues after a legal separation, when the court has ruled that the non-custodial parent has the right to communicate with the minor children, and the abuser continues to terrorize the custodial parent who may be struggling to financially survive. The questioner contends that when finances are drained, the abuser charges that financial advantage now places him or her in position to become the custodian of the children. What can the courts do in cases such as this? Is post-separation abuse something the courts can deal with, or do laws need to be updated? I'm happy to repeat any of it.
I may ask later. I definitely think laws do need to be updated. They always need to be updated. We are an ever-changing society and civilization, so we always need to have the most updated laws dealing with what we deal with. Now, when it comes to, you said, a non-custodial parent using financial means over the custodial one to get custody, what can the court do?
Yes.
Well, for someone to have a change in custody, you have to file a motion for a change in circumstance. So, what's in that motion? That's what I'm looking at. And you don't just grant it, you have a hearing. Both parties can come, both parties can tell their side. If the custodial parent has lost a job, we all know what that looks like since COVID. So what are they doing? Did they move in with someone? Are they looking for work? What's going on with that? You don't necessarily change custody just because one parent now has no money and the other parent has the majority of it. You have to look at the entire circumstances, and it still goes back to the 12 best interest factors. What's in the best interest of this child? Having financial means doesn't automatically give you custodial rights. You weren't given rights in the beginning for a reason. Let's re-examine those reasons. Have they changed? Or are they the same and you're just coming back trying to prove that this other parent can't financially support, well, then maybe we need to increase child support.
Thank you. Let me repeat the question, Mr. Kraus, now that your mic is working, sorry. It concerns domestic abuse which continues after a legal separation, when the court has ruled that the non-custodial parent has the right to communicate with the minor children, and the abuser continues to terrorize the custodial parent who may be struggling financially. The questioner contends that when finances are drained, the abuser charges that financial advantage now places him or her in position to become the custodian of the children. What can the courts do in cases such as this? Is post-separation abuse something the courts can deal with, or, in your opinion, do the laws need to be changed?
Well, I hear kind of several issues in that question, so I'm going to kind of try and break them down individually. I mean, we know that when one side has money and an attorney, and the other side does not have an attorney and doesn't have money, that there's inherent disadvantages within the system. So one thing the court can do is they can partner with the local bar association to provide affordable options for those that maybe can't afford the full amount, can partner with our local legal aid to make that available to those that otherwise can't afford private counsel, and to enhance our self-help desk so that those can be empowered themselves to get the research, the forms, the information they need to be able to successfully defend themselves in court. The system does have inequities when there's one person that can afford it and the other person cannot. Second part of that question that I heard is the system, the statute presumes that a child should have a relationship with both parents. And so it can be very difficult at times to permanently suspend parenting time between a child and a parent. And that's for good reason, right? Most of the time, the vast majority of times, children need to be able to have liberal access to their parent and to be able to see them. The problem is there are some times when a parent, through domestic violence or through other child abuse or sex abuse, can use those issues to terrorize that child. And that's an area where there could be some statutory reform, but I'm not an advocate and I'm also not the legislature. And so that's an area that they need to speak on. I promise to follow the law as written and follow the Constitution.
Thank you very much. This is also for you. Mr. Kraus, working with families who struggle with poverty, addiction, and mental illness is difficult, to say the least. How are you equipped to be effective and fair?
Now, I think this starts with how you're raised. And I think about my parents, Frank and Cindy, and at a very early age, we were the family that was out there at Thanksgiving serving others, working regularly at our local soup kitchens. My parents, when I was 6 years old, left me and left our family for a month to go to Juarez to be missionaries in Mexico. They led by example, and they taught me the importance of being a community servant and somebody who is willing to put the needs of the community above your own needs. And so on the issues of poverty or mental health, I've seen from my 17 years of experience how important those issues are. I've tried to be a good community steward by serving on different various committees in our county and so forth to be able to give back in that regard, and I'll continue to do so if I'm privileged to be judge.
Thank you. Ms. Watts, the question is, working with families who struggle with poverty, addiction, and mental illness is difficult. How are you equipped to be effective and fair?
I think I'm equipped to be effective and fair from having lived through it myself. I grew up in poverty. My mother was in an abusive relationship with my father, and my father was also an addict. So having grown up with that and seeing how my mother struggled to get away, and then once she did, and it was just me and her, how our community took us in and how they helped lift us up. And I honestly don't believe I would be here today if not for that help and not seeing what my mother did for me and seeing the struggles that my father went through. I know how much a community can help someone. I know how much one person can just help someone. My mother's beautician, my mom could never pay her to do our hair, but she chose to do my hair for free. And having my hair done I needed to have it done. I have very thick, coily hair. It's hard to comb, and getting it done costs hundreds of dollars. But our beautician did it for free. Just having people in your community just to help you, not even knowing what you're going through, just having that help. I know how important that is, and that's why I want to be a judge. That's why I became an attorney. I just want to help people. I want to lift people up. My mom had so much help, and she had positive experiences with the court, and I just want to pass on the help we received, that I received, and how that still sticks with me today.
Thank you. Another question. What professional and personal experiences will help you be culturally sensitive to the needs of the litigants and families before you? Culturally sensitive. What professional and personal experiences will help you, some of which you already talked about, be culturally sensitive to the needs of those who appear before you?
Professional experiences is, I think I got while working at Legal Services and working here for the county as a public defender. Just seeing how scared people are on arraignment day, and they are so afraid that they are going to jail. They are so afraid, they're crying, and I am doing my best to console them. And I know they're not going to jail, but I cannot tell them that. And just seeing that, this is the worst day of people's lives when they're in court. It could be on an arraignment day, a pretrial, a final pretrial, a sentencing, a jury trial day. They do not want to be there. And just seeing how just showing compassion and listening and just being that lending ear, even though it takes them more time, how so much calmer people get, how so much more relaxed they get. And they always thank me. Thank you so much for listening to me. Thank you so much. I just had to get that out. And I learned to do that while working for Legal Services, and I see it a lot here. And the personal is what I expressed already, having gone through what I've gone through and seen what I've seen. You never know what someone is struggling with. And so it's always best to treat people how you want to be treated, and that's with respect.
Thank you. For you, Mr. Kraus, what professional and personal experiences will help you be culturally sensitive to the needs of the litigants and families who appear before you?
Sure. For me, it starts with treating everybody with dignity and respect. So all of those that you interact with receive dignity and respect, irrespective of socioeconomic background or race issues or gender issues. But it doesn't matter. If they're before your court and would be appearing before me, everybody is treated with that dignity and respect. In private practice, I always tried to have one pro bono case going at all times. Those are cases that you don't receive financial compensation, but it's a way to be able to give back to your community. And I always received much more from that experience than what I could give, frankly, because you learn the journeys of those that needed help through the legal system. And I carry those stories and those journeys with me today. It's not just about those that have big dollars or can pay an attorney, but it's about achieving justice in court and being fair to all.
Thank you. Question: how do you plan to engage the community, families, service providers, and CPS in promoting child safety, permanence, and reunification?
It's so unbelievably important, and the state has put a greater emphasis on achieving permanent stability and finality for families. You can't have children that are languishing within the system without permanence. And so it's this balance. Our local DHS really does a nice job of working from the beginning to put services in place for families, to give them a hand and to pull them out of whatever circumstance they have. Some families, that can be done pretty quickly. Other families, not as quickly, because there can be generational abuse, or there can be issues that are very difficult to work through in a few months or even a year. So you need to have very individualized analysis and good common sense on cases, so you know when it's time to go to a more permanent option, such as termination or guardianship, or another option, or to give that parent even more time to be able to rectify whatever the barriers are within their family. Individual analysis is the key, and always remembering that this is a child protection proceeding and doing the best you can to keep that child safe.
Thank you. Ms. Watts, let me just repeat the question quickly. How do you plan to engage the community, families, and service providers in promoting child safety, permanency, and reunification?
I think by getting out in the community and being involved in the community. Throughout this campaign, I've gotten very involved in the community, and I'm so happy with what I've seen, like getting involved with Community Action House and Lighthouse and Women of Color Give, and finding out about these nonprofits like Grant More Hope and Family Ministries, and them learning what I do and me learning what they do and how I can pass on those resources for people in need and how they can pass on the resources I have for people in need. I think getting out in the community, seeing your community members in Ottawa County is a huge county. So that can be difficult, but it's worth the effort to just get out, make yourself known, make your agenda known, and seeing what's happening in the communities that you serve, because you do serve everyone in this county. So it is important to know what's going on in this county. What do they have to help others in this county? What are they lacking in the county? And what can you do to help them help others?
Thank you. What is your view of spousal support generally?
My view of spousal support is that I relied heavily on the spousal calculator. And even with the calculator that you put in their information and, who did what and highest level of education, even then, I would always want the parties to help decide that on their own. I think, again, that's where mediation also played a big role, because sometimes if you're getting spousal support, you're not getting child support, or you're getting little child support. And so when it comes to spousal support, I think the calculator is very important because it shows what it could be. That doesn't necessarily mean that's what the judge is going to rule on, but it also gives parties a starting point when it comes to talking things out and having a little give and take so that everyone can live with the final decision.
Thank you. Mr. Kraus, what is your view generally of spousal support?
Well, I think my role is to follow the statute and follow also the case law that's out there. And that would suggest that you have to look at the incomes of the parties, you have to look at the length of the marriage, you have to look at the equities in the situation. Did somebody get all of their education, for example, based on kind of the family's resources? Maybe somebody went to law school or went to pharmacy school or became a doctor, while the other partner or spouse stayed home with the children. So these things are pretty complex. You can use the formula as a starting point but it's important to do individualized analysis with a family to try and get to a just result that takes into consideration many, many factors.
Thank you. Last question.
Wow.
What do you believe is the greatest injustice in the family court system that you wish to fight for?
The greatest injustice within the system. I think it's important that we have competent counsel and guardian ad litems that are in court fighting for both children and fighting for parents. Also having strong prosecutors and well-educated judges. The system works best when you have a system where there is balance and equality, and you have everybody working their hardest to further the goals of their individual clients. We're really lucky to have that in Ottawa County. We have very competent judges that are seasoned, have years and years of experience in this area. We have guardian ad litems that regularly are working with children in the community, meeting with children, understanding what the children's needs are and advocating for those children. We have prosecutors that just don't look at cases as files, but are doing individual analysis and doing their best to come to just advocacy within the court. So when all of those parts work, like we have now, to try and ensure that that continues on into the future is essential, because that's in the best interest of children and families.
Thank you. Would you please tell us what you believe is the greatest injustice in the family court system that you wish to fight for, Ms. Watts?
I believe that the greatest injustice is that there is no indigent defense for juveniles. So in 2013, there was a statewide law that was passed that was to do away with the appointment system and create a public defense office for all the cities across the state of Michigan for a variety of reasons. Why this wasn't done for the most vulnerable in our community escapes me. I am glad that it is part of one of the policy reforms for the Juvenile Justice Task Force, because I believe it's so important that our juveniles, they need reliable defense, they need affordable defense, and they don't have that right now. Right now, they still have the appointment system or, the contract system, which I don't necessarily agree with. So I like that the task force has recognized that this is a problem in our juvenile court system, and they aim to remedy it.
Thank you. And thank you all for being here this evening. You've been a wonderful audience. Thank you for submitting questions. We'll now give the candidates just a very short minute and a half to sum up. And closing remarks, Mr. Kraus, please start.
What a pleasure it has been for me to get all through Ottawa County to be able to campaign for this position. I have been all the way from Holland, north side of Holland, where I reside, all the way up to Chester Township and everything in between, whether it's Jenison, Borculo, Georgetown Township, Grand Haven, Spring Lake. I promise that I will be accessible to the citizens, to know our community, and to use my 17 years of experience in every way I can to better families and children within our community. I further promise that I'm not beholden to anybody. This is a nonpartisan position. This shouldn't be a Democrat position or a Republican position. This is a position that should treat everybody with dignity, fairness, and respect when they come into that courtroom, irrespective of their political ties, their backgrounds, their socioeconomic status. Promise that if you ever get in my courtroom, I'll give you a fair shake. I'm somebody that's going to listen. I'm somebody that's going to take a deep breath before I rule, because we need somebody with the right temperament, judgment, experience to serve the most vulnerable in our community, our children and our families.
Thank you. Ms. Watts, minute and a half for your closing statement. If you want to stand here, that's fine.
Oh, no, I'm good.
I
I just want to thank you all for coming out. I really appreciate it. This is my first time ever doing a forum like this. Usually when I'm at forums, I'm in the audience, I'm asking the questions, so this was definitely a new experience. And this is my first time ever running a campaign. It's been an experience. But I do have to say I have loved getting out in the community and really learning just how big this county is. I have met some of the nicest people, and I've been to townships I did not even know existed, like Wright Township and Crockery Township, and I plan to move there one day. I absolutely love going out there. It's so much fun. And I just really like getting involved in the community. I like helping people. This is what I want to do. This is what I've always wanted to do. I won't stop fighting for my community. I won't stop fighting for people in need because it will always be there. And I believe as long as there's someone like me who is out there who recognizes that people are struggling with their own things, and that just having a compassionate talk or a look or anything like that, and just being an open and honest person, that will take you really far. So I just want to say thank you.
Thank you. And here's Paula.
Not Paul.
Paula.
Now is the time that we applaud our candidates, Mr. Kraus and Ms. Watts. They both worked very hard tonight answering questions from the audience and from our various sources. So thank you. We hope you as voters have gained insight into their positions, and to learn more, both candidates in this circuit court judge position submitted answers to questions on our Vote 411 website. So if you want further information before you make your decision, please sign on and look at their answers. They both completed them. This has been videoed. We will post it on various, on the bar website, or a link to it, and as soon as we are able to upload it to our website. So stay tuned if you want to go back and look at it within, a couple of days, or tomorrow? A couple of days. All right, there we go. Again, thank you. The League of Women Voters loves engaging voters and candidates so we can make informed decisions at the polls. And please keep November 8th on your list and calendar and vote. Thank you.
Yes, I know. Yeah, you had two candidates who showed up. Hi, nice to meet you.
You've been with the defense's office
Yeah.
a year?
Almost. Like,
We were trying to get yours
On my docket, so we
Should I turn it off or did you get it off?
I'm Mark Fine, nice to meet
hi,
you.
nice to meet you.